I have put tens of millions of dollars into the pockets of my automobile accident clients through settlements and judgments. Hello, I'm attorney Louis Haskell. And now that I've told you that I put tens of millions of dollars into the pockets of my clients, I am proud to tell you that I have not recovered $1 billion in settlements, judgments, and benefits, as some lawyers who advertise constantly about how many billions they've recovered. And I'm proud to tell you that I have not recovered $100 million in settlements and judgments, which is really, frankly, more relevant because that is not the important number. I mean, who cares how much my clients have received in weekly checks or how much medical bills I've gotten paid? That really doesn't tell you anything about how good, bad, or indifferent of a lawyer I am. But even in terms of settlements and judgments, it's nice to have that big number. After all, I get a third of it, right? That's how a lawyer gets paid, a third of what they recover. And of course, it's an important number to the client because obviously they're not going to get more than they recover or even more than two-thirds of what they recover. So it's an important number there, but it's hardly the be all and the end all, quite the contrary. And here's a good example of what I'm talking about. This is a disbursement sheet from an attorney who advertises a lot in the state of Massachusetts and has been doing it for a very long time. And in this case, he recovered, right? He recovered $6,666.66 for his client. In fact, he probably got another $2,000 in PIP benefits. So in terms of settlements, judgments, and benefits, 8666.66. But let's look at what the client got. The client walked away from this case with $716.69. And I've seen from other lawyers who advertise heavily bragging about their recoveries, and the clients are walking away very often with very short money. And so let's see what's going on here. First of all, we see the attorney nickeling and diming the client over expenses. Medical records at 2964. In a case like this one, in a typical case, I would just waive that off for the very simple reason that if you're getting a decent settlement, your fee is $2,200. You need to worry about $29.64. Nickeling and diming clients is not a best practice. And look at this postage at 74 cents for a first class letter. I guess it is worth tracking now, but it's generally not worth tracking. And I don't know what he's doing that he has phone charges. But this is much more offensive right down here. Investigation. In this particular one, this accident required zero investigation. It was actually a very famous case. It was a drunk driver who just destroyed the other car. 4 people were injured, one just horrifically, and it was a 2040 policy. Nobody could get more than 20,000. Everybody couldn't get more than 40,000. So the one person who was just horrifically injured got the 20,000. 3 other people were hurt very badly, and they got the other 20,000, split among themselves. So 66 each. And so this investigator is really the paralegal. He goes to sign up the client, take their statement, get their information. He gathers up the police report. In this case, because the newspapers did cover the accident, I would imagine he went online and gathered up the newspaper articles. But really, there's no need for a real investigator here. This is paralegal work. In my office, we do that kind of thing ourselves. I pay for it because I pay these people by the hour. It's not part of the case. And it's just not a charge to the client. Imagine if lawyers started charging for their secretaries and their paralegals and whatnot on a contingent fee. Now, they do it, of course, when they're billing clients all the time, but on a contingent fee, it'd be crazy. But here's what's really offensive. This person went to a chiropractor, and this chiropractor isn't on any health insurance plan. It doesn't bill health insurers. It just waits to get paid out of the settlement. Now, I encourage clients to come and see me as soon after the accident as possible, in part because I want to make sure we avoid such people. These bills should have been paid by health insurance and by PIP. And worse than that, these medical bills, they're $3,467 here. In this case, more than half of the settlement. If I find myself in a situation where, let's say the client came in after they were done treating, and I'm stuck with an unpaid doctor's bill, stuck with an unpaid chiropractic or unpaid physical therapy bill, I would at least call the provider, and they'd usually cut it in half. In a case like this one, where recovery is limited by the amount of insurance available, not by the amount of injury, I would expect actually to cut it by more than half, but certainly in half. But this one wasn't cut at all. So we wind up with a situation in which the providers are walking away with most of the money. Lawyer, who do you work for? Who do you work for? Do you work for the providers? Do you work for the client? Who do you represent? To whom do you owe a duty? And that's not a hard question. Your duty is owed to your client. And so to create a situation like this, where you get a $6,600 settlement, the doctors are getting, almost 3,500 of it, and the client's getting a little over 700, that's just wrong. Now, if I were stuck in a situation like this, and we try like crazy to avoid it, part of proper case management is understanding who the problem clinics are, who the problem providers are, who are the people who are going to make these kinds of problems for you. And frankly, where the medical doctor is also part of the problem, it looks like this lawyer didn't even try to do the coordination of benefits, which is, again, part of the case. It's funny because I credit him actually with not charging for PIP administration. I've seen lawyers charge, up to 20% for getting the medical bills paid for what the, no-fault carrier pays. And that's just wrong. I mean, look, it's legal if you disclose the fee. It's like, get a decent settlement, live off your third, run your office off your third, stop trying to mess over your clients. Look at this. Part of the job is to manage the case properly so that you don't run into these problems. And we've been very good over here about avoiding these problems. But if we've ever been in a situation like this one, I would have just made it so that the client and I got the same amount, which would be, in this case, roughly $1,500 each, because the client and the lawyer are getting roughly $3,000. Fortunately, I haven't had to do that very often, but I've done it. There is an exception, which is child support enforcement liens. If child support is taking everything, then legally I can't give the client anything, even if it comes out of my fee. But this is why I get so bothered by lawyers bragging about how much they've recovered, when the correct metric, when what really matters is how much is the client getting. And in my office, in most cases, the client's walking out with 2/3 of the recovery. I take a third. The vast majority of cases, I waive off my expenses, and we try very hard to avoid letting anybody else stick their fingers in the settlement pie, so that we can brag about the fact that I have put tens of millions of dollars into the pockets of my clients, even though I don't have these lofty numbers in terms of recoveries, but that the lawyers who spend vast sums advertising love to tell you. So be aware that there really is a difference between recovery and what the client gets. Getting a maximum recovery is part of that, but it's not all of it. And therefore, we think that we are a better choice than any of these people who you see on the billboards or on the television and that sort of a thing. So if you have had the misfortune of being injured in a car accident, or really anything, dog bite, slip and fall, please don't hesitate to call on me. Thank you.